Welcome to the I Got Fired podcast, where we help people who've been fired or afraid that they might be, or just curious about employment law. I'm Tom Spiegel, founder of the Spiegel Law Firm, and a little bit of legalese before we get started. This program is for your educational purposes only. It's not intended to establish an attorney-client relationship with you. If you want specific legal advice for your problem, you got it. You should go see a lawyer. So today's the second episode in our series where I go through from start to finish, the nuts and bolts of a civil lawsuit, which includes employment law lawsuits. And last week we talked about the opening salvo in any piece of litigation, civil litigation. Again, when I'm talking about civil, I'm talking about anything where you don't go to jail. So for a criminal law, when I'm talking about criminal law, so any kind of civil litigation, the opening salvo is the complaint that we talked about last week that the person who is suing, called the plaintiff, files. And in most employment cases, it's the employee who is the plaintiff, the one who is taking affirmative action. I will note there's some tactical advantages to this, right? If you are the one filing a complaint, you're the one who gets to choose when it's filed and what goes in it. And that's not a luxury that defendants have. They only get to get involved in the lawsuit once it is started. So while there are many in some ways disadvantages to being a plaintiff in employment lawsuit in particular, it is a significant advantage that you get to choose the time and the place and really the substance of what you put in your complaint. That said, there are some times in employment law when the employee is the defendant. So your employer, usually your former employer, is the one who gets to file the complaint. This is particularly for non-compete, where you've signed a non-compete agreement and you've left to start a new job or start your own company, and your former employer, and they're usually, again, like any piece of litigation, they're usually letters that go back and forth beforehand. They don't usually just run off and file a complaint. But once all that falls through, then your employer will be the one to file the complaint that says that you violated the non-compete. Other cases are breach of contract cases that apply to professionals. So, for instance, if you're a dentist and you're part of a practice and you've signed a contract for your employment and you leave and your employer, the practice, thinks you violated the contract, they could file a breach of contract, and then so your employer would be the one to file that complaint. But in most instances, it's going to be the plaintiff, which gets me to my next piece, and it really goes along with the complaint, but I wanted to have a separate episode on it because it is so important and in certain circumstances can be difficult, and that is serving the complaint. So, right, you've filed it, you've gone to the clerk, you've gotten your file stamp, it's official, it's in the court system. Well, the case hasn't started yet, because you have to go through a specific process to show that the defendant knows they're being sued. And the reason this is so important is if the defendant, let's say that you filed the complaint and you've properly served it, I'll talk about service in just a minute. If you have done that and the defendant fails to answer, then you can get what's called a default judgment, which, it's basically the judgment you get when the defendant fails to show up. Essentially, you win the case because the other side didn't even show up to compete. Now, you often will still have to prove damages, right? Prove that you are injured. So there often what will happen is, the court will say, well, I find that the defendant is liable. The plaintiff has pled a case appropriately, and the defendant hasn't defended themselves, so the defendant is liable. Now the question is, how much does the defendant owe? And then you'll come give testimony. You can even put on other evidence about the damages that you had suffered. And at the end of it, the judge will issue a money judgment against that defendant. And if the defendant doesn't pay it, and there are certain processes you have to go through with this, but essentially if the defendant doesn't pay it, you can have, depending where you are, the sheriff's office, the marshals show up at that defendant's place of business and shut it down, basically force a sale of certain, property of the business in order to satisfy the claim. So, I mean, these are the people with guns who would show up and enforce that judgment. So that is why it's so important. You can't just file a complaint and say, well, I've sued them. And you know, they didn't show up. You've got to show to the court, and you've got to jump through certain hoops to show that the defendant has gotten lawful process before you can get that judgment. The other reason that it's important to separate this out, as we talked about last time, I believe I did, you know, if one of your objectives is to stop the statute of limitations in your case, let's say you've gone to the EEOC, and as in most instances, you know, that process has completed and there was either no mediation or mediation was unsuccessful, and you get your right to sue, and you have 90 days from the issuance of that right to sue to file your lawsuit. And if you don't do it within those 90 days, your case is over forever. And sometimes it can be very difficult to find, because at that point, it is possible to handle these cases pro se. By that, I mean by yourself, but it's very difficult. So at that point, you really need a lawyer. And most people, that's what they do. They go out and try to find a lawyer. And it can be difficult sometimes to find a lawyer to take a case within that 90 days. Certainly not impossible. We do take those cases. Other lawyers do. So not trying to discourage you in any way, but it is not uncommon, particularly if you wait, right? Let's say you sit on that right to sue for 60 days and decide, you know what, like I really want to pursue this. And so you've now only got a month left. You may be difficult to find a lawyer who is both willing and capable of getting your case ready to go within that 30 days. Again, it can happen, happens all the time, but it does limit your options. So you could be in a situation where, you know, you've got a decent case and you just haven't been able to find a lawyer to be able to get that complaint filed for you. You know, then you can file it yourself. If you file it in federal court, you get an extra 90 days. You got 90 days to actually serve it. Okay. So the complaint's been filed, but the lawsuit hasn't started. Nothing is going on. All you've done is stop the statute of limitations. And that's not inconsequential. That could be a great thing. That may be what you're trying to do. In state courts, you may get additional time. For instance, in Virginia, you can file a complaint in state court and you get a year before you have to serve it. So, you know, this can be a great sort of tactic for you to use to both stop the statute of limitations and give yourself some time to find a lawyer and or save up the money to hire one if your case is not one that is, you know, the lawyers take on contingency, or you haven't found someone to take on contingency. You know, it kind of puts a stop button on that statute from running and gives you time to, excuse me, catch your breath, find a lawyer, pay for a lawyer, whatever it is that you need to do. There's, you know, do you serve it in state court or federal court? Again, this is why it's helpful to talk to a lawyer beforehand, even if you only hire him or her for an hour to kind of go through it. Different strategies on where you file. In most employment cases, you can file it in either state court or federal court. Getting a little bit into the weeds here, but in most instances, if you file it in state court, defendants will do what's called remove it to federal court. Again, the case is still good. The statute of limitations is still stopped, but the defendant says, hey, you know, this is a matter of federal law and it should be removed to federal court, even though a state court is perfectly capable of hearing them. Of course, it's different if you're filing a case with primarily state law. For instance, if you're filing under the Virginia Human Rights Act and your 180-day statute of limitations is about to run, or you're filing under the DC Human Rights Act and the District of Columbia, these are just examples, all kinds of different state laws. Those you're gonna have to file in state court. But anyway, I'm getting a little ahead of myself, and you see why this gets so complex. And so even if you're in a situation where you're trying to stop the clock and buy yourself some time, it's usually well worth, you know, the $500 or so that you would pay, sometimes less depending on where you are, that you would pay to talk to somebody to kind of give you the strategy on what's the best strategy and what choices you face. But let's assume you've made that choice and you've gone and you have filed your complaint appropriately. It's now file stamped, or it's in the electronic, it's in Pacer if you're in federal court, and you're good to go. So now you have to to make sure you have to go through the legal process to serve the defendant. Now, in some cases, that can be relatively simple. If you are serving a business, then they are required to have a registered agent to accept, for all kinds of purposes, but to accept a lawsuit. So if you are appropriately doing business in let's say in the Commonwealth of Virginia, like our law firm, we have a registered agent. And if somebody wanted to sue us, you can go to the State Corporation Commission in Virginia, but any of the whatever state agencies registers businesses, you would go to that. You would go to that agency. Most of them have a website. You can just type in your employer's name and other information, and they will give you the registered agent. And you just got to get the complaint to that agent. Often it's just there's not necessarily somebody sitting there. It's just a place where you can, drop off paperwork. Frankly, I have never done this in person myself, because usually what we do, and what I would recommend you do, is you hire a process server. This is their whole job, right? Is what we call serving process, which has to be done for not all kinds of legal documents, not only complaints, but in some cases, certain kinds of subpoenas and other records have to be served. And process servers, and you can go wherever you are, type in process server, Arlington County, process server, Washington, D.C., and you're going to pull up a number. It's usually relatively inexpensive. $100, maybe $200 less, depending on where you are, to get that process server, to make sure it's properly sent to the registered agent. And as long as it's gotten to the registered agent appropriately, then you will have served them. And then the process server will either give you, or sometimes will file themselves, the paperwork that you need to show the court that this has been properly served. And once that paperwork is filed, then the case is started. Now, let's say it's not a business, then you don't have a registered agent and you are serving an individual. This is where it gets very complicated. There are a number of different rules, and they vary by state. For instance, some states will allow you to go to that person's home address and leave your paperwork with someone who is over the age of 18. In certain circumstances, you can actually post the paperwork on the person's address. Again, it can vary by state, and it can also vary on the matter that you are filing. But in most instances, you've got to actually hand it to the person. And that's why you've seen in the movies, somebody, and this actually happens, right, where somebody walks up and hand somebody a piece of paper like you've been served, or they throw it, like the person would have to accept it. I mean, you could toss it at their feet. You just have to have somebody that can sort of sign an affidavit, which is what these process servers do, that, I personally serve so-and-so defendant on this date and this location. Often they'll have like a description of what the person looked like. And again, they're really trying to make sure you serve that actual person, because again, if they don't show up, the court can issue a default judgment and send the people with guns to enforce that judgment. So this is a very serious matter. So anyway, but that's what happens. You hand it to the person, and this can be difficult. You've probably seen this in the news where people will do what's called evade service. Make it difficult for you to find them, run from you or hide from you. The really rich folks can be very difficult to serve because they've got people to help protect them. There are things you can do if you can show that the person has been purposely evading service. Then there are alternative means of serving these documents. Again, it varies by state. In that situation, you really want to be working with the process server. And again, if you are if you've invested all this time up to this point anyway, where if your case is potentially worth a significant amount to you, then it's worth paying a process server a couple $100 to help make sure this is done and is done right. Again, it's possible, particularly if it's a business, for you to take it to the registered agent on your own. Again, a registered agent, that's their job, is to accept service. They're not going to be hiding behind dumpsters and flying to different states and that sort of thing. So if you can go and take the proper paperwork, and again, make friends with the clerk in the court that you are serving this in, because she or he can help you often. They can't provide legal advice, but make sure you have the right paperwork to make sure you get that service done appropriately. In cases where, let's say you filed your complaint, let's say if it's in federal court and the 90 days lapses, well, then your case is going to be dismissed and it'll be over, particularly if the statute of limitations is run. If it hasn't run, then it's going to be dismissed, what's called without prejudice, which means you can file it again. So let's say your case is one in which you don't have to file with the EEOC, and you've got let's say it's a Section 1981 case, which involves issues of race and national origin. You've got a 1981 case. It's a 4-year statute of limitations. You file your complaint on year 1. You weren't able to properly get it served. It's dismissed. You could still refile it. The game isn't over. But if the statute of limitations is run, then you as soon as that complaint is dismissed, even if it's dismissed without prejudice, you can't file it again because your statute of limitations has run. So you do need to watch those deadlines. Again, that's why if you have the option, for instance, if you're here in Virginia, and what you're trying to do is buy yourself time, file in state court, consider, talk to your attorney or consider filing in state court, because you buy yourself a year as opposed to 90 days. So that is the importance of service. It is, for the reasons I've talked about here, very important in a separate process from filing the complaint. And it is what really kicks off, really starts the machinery of the court going. Because when you have served the complaint and served process, then the defendant gets some documentation from the court telling them that they've basically been sued, and depending on the court, it's either 21 days or 30 days to answer your complaint. And that's what we'll talk about next. But that's when the case really gets going. That's when it's assigned to it's officially assigned to the judge, and the process gets started. Before that, if you've just filed the complaint, nothing is happening except you've taken the first half step. You've stopped your statute of limitations. You got your foot in the courthouse door, but you haven't opened it all the way. Once you've filed service appropriately, which again, I would recommend, all things being equal, that you go find a process server to help you with that. Once that's done, then game on, right? The lawsuit has officially started. There'll be some requirements from the defendant to answer the complaint, and that's what we will talk about in the next podcast episode. If you have found this helpful, it's really would be useful to me if you would like and comment on this episode and whatever app you use to listen to podcasts. It helps people find us. Also, if you are interested in getting more information about the latest and greatest in employment law and other tips on how to keep your career headed in an upward trajectory, then go to our free resource, which is thecareerrocket.io. You got to put the in there, thecareerrocket.io. And if you want to, you can enter your email there, and you'll get weekly free information, again, on the latest and greatest in employment law and other tips and tricks on how to make the most out of your career. I hope that you found this helpful, and I wish you guys the best of luck out there.